Calling civil action 17-6011 related to 17-6012, the people of the state of California versus BP PLC et al. Counsel, please approach the podium and state your appearances for the record.
Good morning, Your Honor. Jonathan Hughes of Arnold & Porter for BP PLC.
Okay.
Good morning, Your Honor. Tracy Renfro with King & Spalding on behalf of ConocoPhillips.
Good morning, Your Honor. Theodore Boutros for Chevron.
Good morning, Your Honor. Jaron Jangarbani from Paul Weiss on behalf of ExxonMobil.
Good morning, Your Honor. Elizabeth Kim from Munger Tolles on behalf of Defendant Royal Dutch Shell PLC.
Good morning, Your Honor. David Frederick from Kellogg Hansen for Royal Dutch Shell.
Good morning, Your Honor. Eric Grant, U.S. Department of Justice for Amicus Curiae, United States of America.
Good morning, Your Honor. Rufus Justin Smith, also U.S. DOJ.
Thank you to all of you. And?
Good morning, Your Honor. Steve Berman on behalf of the people.
Berman.
Good morning, Your Honor. Benjamin Crass on behalf of the plaintiffs.
Good morning, Your Honor. Maria B. on behalf of the people of the City of Oakland.
Good morning, Your Honor. Malia McPherson for the City of Oakland and the people.
Good morning, Your Honor. Matt Goldberg on behalf of the people in the City of San Francisco.
Good morning, Your Honor. Rob Kaplan on behalf of the people in the City and County of San Francisco.
And welcome to all of you. Again, I believe the TV camera is operating for recording today's events, so keep that in mind. All right, we have a lot of issues. I have maybe an hour and a half we can spend on the case this morning. One of the issues is the personal jurisdiction issue and service of process, and you sent in a notice that a junior lawyer was going to argue the service of process issue. Who is that?
That's me.
All right, please come forward and make your argument.
Elizabeth Kim from Munger Tolles on behalf of Defendant Royal Dutch Shell PLC.
Okay, please go ahead.
Thank you, Your Honor. I'll be addressing the 12B5 motion to dismiss for insufficient service of process, and my co-counsel, Mr. David Frederick of Kellogg Hansen, will be arguing the 12B2 motion to dismiss for lack of personal jurisdiction. Your Honor, the court must grant the 12B5 motion to dismiss for insufficient service of process because under California law, it is very clear that a general manager is an entity or a person that manages a foreign corporation's continuous flow of business from the foreign corporation to the state of California. Plaintiffs have not and cannot allege that Royal Dutch Shell has such an entity or has such a general manager because, for one simple reason, Royal Dutch Shell is only a holding company. It has no operations, it conducts no business, and so it cannot, by definition, have a general manager anywhere, much less in the state of California. Each of the cases...
Now, whose word do I have for that? Is there a declaration someplace?
There is, Your Honor. The Szymanski Declaration, which was submitted with Royal Dutch Shell's 12B2 and 12B5 motions.
And do I just have to take that declaration at face value and not allow the other side to cross-examine that person?
Your Honor, a cross-examination here would serve no purpose. The burden is on plaintiffs.
You say, but how about them? Do they agree with that?
I doubt it, but they haven't...
So maybe we have to, maybe this is all premature and we have to do some discovery.
Respectfully, Your Honor, I don't think discovery would help plaintiffs in this case. The burden is on them to show that service was proper. In order to do so, they could have alleged facts demonstrating that, for example, Royal Dutch Shell actually does transact business, and Shell Oil Company, the entity that they serve.
They need discovery to prove that. They don't have to allege that in the complaint.
Even if they could have discovery, Your Honor, as a matter of fact, it is not possible.
Very likely you're going to wind up talking yourself into discovery, and all those people in the Netherlands are going to be sitting around deposed, and everything else is going to be put on hold while we decide your motion. That's where we're headed, because you are making this argument based on, quote, facts. The other side says that you have subsidiaries. I have heard of the Shell Oil Company.
Yes, Your Honor.
They work in this state. They say that Shell Oil is your general manager for conducting your worldwide operations right here in our state. Why isn't that true?
Because Royal Dutch Shell doesn't conduct any operations, Your Honor. The term general manager, as it's been interpreted by the California Supreme Court, is limited to a person or an entity that actually manages the continuous flow of business from a foreign corporation. So, for example, Your Honor, each of the cases that plaintiffs cite involved a foreign corporation. For example, in Yamaha or in Contrarian, the Toyota case, the foreign parent manufactured a good, a car. They had a domestic subsidiary in the state of California that sold the cars on their behalf, dealt with customer warranties, dealt with customer complaints. They had total control. That domestic subsidiary had total control over the foreign corporation's business in California. It is because there was that continuous flow of business from the foreign corporation to the state of California, and because that flowed down to a domestic subsidiary that was wholly responsible for either selling the goods, distributing the goods, managing the goods, it's under those circumstances that the California Supreme Court said that that served entity qualifies as a general manager. There's no way plaintiffs can make such an allegation about any subsidiary here because Royal Dutch Shell is merely a holding company. There's nothing that Royal Dutch Shell does, no business that it conducts, that could possibly be managed by any corporation, much less by Shell Oil Company in the state of California.
All right, so you're drawing a distinction between a holding company versus a operating company that, for example, manufactures product and uses a subsidiary to distribute it.
Yes, Your Honor.
All right, so and you're saying the Cal Supreme Court has made that very distinction?
In the seminal case, which is still binding authority, is Cosper, Your Honor, which is at 53rd Cal 2nd 73. And on page 84, the Cal Supreme Court says that the essential factor, quote, in determining whether or not the agent there was a general manager is, quote, they were performing services for Smith & Wesson, the foreign corporation at issue, and providing it, Smith & Wesson, with the opportunity for, quote, regular contact with its customers and a channel for continuous flow of business into the state. Now, when it's referring to its customers, they're talking about the foreign corporation. So the reason why the general manager, the reason why Lookabout in Cosper was considered a general manager was because that person managed the flow of business from Smith & Wesson, a foreign corporation, into the state of California, and it managed the sales, the distribution, and customer complaints. That's true of every district court case that plaintiffs cite. These cases simply are not on all fours with what we have here, which is simply they picked one of 1,100 subsidiaries of Royal Dutch Shell. They picked one that happened to have a registered agent for service of process in California and served that entity. But that entity does not manage any of Royal Dutch Shell's business anywhere because Royal Dutch Shell doesn't transact business, Your Honor.
In the Cosper case in the Cal Supreme Court, that involved a parent corporation and a subsidiary.
No, it did not, Your Honor. Actually, it involved a foreign corporation that had a sales representative that managed, I believe it had an arrangement to sell Smith & Wesson guns in the state of California.
Right, so in that case, there wasn't even a corporate difference. There was just a foreign corporation with agents hired in California. Is that right?
Your Honor, it wasn't analyzed as an agency relationship. It was analyzed under the general manager provision of the statute. And applying that, interpreting that phrase from former Corporations Code 6500, the California Supreme Court said that the essential factor is whether or not this general manager is managing a foreign corporation's business to the state of California.
Well, my question is, was the general manager in that case an employee of the overseas company?
He was not, Your Honor.
So it was like an independent agent or something?
Yes, Your Honor,
Okay.
Sales representative.
All right. So a subsidiary could be a general manager, right?
Yes, Your Honor.
So the distinction you're drawing is that it has to be the flow of goods, and a holding company doesn't do goods. It's just a holding company.
Well, the cases up until this point that plaintiffs rely on all involved goods. They all involved manufactured goods, for example, cars. And so as a helpful case on this point, so in Yamaha, the parent corporation, Yamaha Japan, actually manufactured the cars that were sold in California. Its domestic subsidiary, Yamaha America, sold the cars, was the exclusive seller, distributor, licensed to that question, but what I can tell you is that the question here is, does a foreign corporation essentially have the same business advantages, it's another phrase that's used in the California case law, have the same business advantages and access to their own customers through another entity or another person in California, such that they have the same advantages as if they had their own offices there. Royal Dutch Shell, as merely a holding company, transacts no business, it offers no services, it sells no goods. All of this is in the Szymanski Declaration, and plaintiffs don't allege otherwise. They have no reasonable basis to conclude otherwise. There's no fact that plaintiffs could uncover that changes the underlying truth that Royal Dutch Shell doesn't transact any business, and so by definition, it cannot have a general manager.
All right, just stay right there. I'm going to give the other side an opportunity to reply, and then I'll give you a rebuttal. Okay, what do you say to what I've heard?
May it please the court, Benjamin Crass. Your Honor, the plaintiffs have submitted a lot of evidence that Royal Dutch Shell is not a holding company with respect to the key tortious issue in this case, which is the decision to produce company-wide levels of fossil fuel.
Can we turn that microphone a little higher or crank it up so that it's a little closer to your voice?
Is that better, Your Honor?
A little better, but let's go up. Can you make the volume a couple of notches higher? Well, but how can that be, Ms. Kim? It's Ms. Kim, right?
Yes, Your Honor.
Just got through telling me that it was a holding company and that you're stuck with that, and you can't dispute that.
We can dispute it, Your Honor.
No, you can't, because the big company has said we're a holding company, and you as the plaintiff are stuck with that.
We're not stuck with that, Your Honor. If we come forward with facts, we've alleged facts.
What facts do you have that show to the contrary?
Yes. I would point, Your Honor, first of all, to Royal Dutch Shell's response to the Carbon Disclosure Project questionnaire on climate change in 2016. And Royal Dutch Shell was quite clear that it was the parent company that makes decisions in terms of climate policy for the company as a whole. And that is relevant to production because that is one of the key inputs that goes into the decision to produce massive amounts of fossil fuels on a company-wide basis. And so the fact that the parent company is the one considering the key input to the decision to produce fossil fuels is very strong evidence that it's the company that makes the decision. It's not a mere holding company. I'd also point, Your Honor, to the testimony from Shell subsidiaries in the Greenpeace case from federal court in Alaska from a couple of years ago. And the testimony was that the board of directors of Royal Dutch Shell was the one to approve the decision to drill for oil in Alaska. That was the parent, not the subsidiary. A November 2017 announcement by Royal Dutch Shell's CEO saying that Shell was going to aim to reduce its carbon footprint, not only of its own emissions, but of the emissions from the products of its consumers. And that was the Shell CEO taking responsibility for Shell products.
When you say Shell, do you mean Royal Dutch Shell, or do you mean the Shell in California?
Royal Dutch Shell, Your Honor. It was the CEO that made that announcement. So we've submitted a lot of evidence, Your Honor. In terms of Shell Oil Company, we have alleged...
Do you agree that if it was a holding company that it would, let's say it's a holding company and does, like the motion suggests, do you lose?
If it's a mere holding company that does nothing else other than hold investments, which is not what the evidence shows that we have submitted, then Shell Oil Company would not be the general manager for purposes of service of process.
So here I am, I have conflicting evidence. I'm going to give you a chance in a minute to respond to the conflicting evidence, but what am I supposed to do? I can't just take your word for it either. Do we have to have a trial? How do we resolve this issue?
We've put forward sufficient evidence. If Your Honor thinks that we need to put forward a more factual basis.
One time I had on a service of process issue, I had an evidentiary hearing. We had witnesses. It went 2 days. because the issue there was, did the service process guy actually drop the thing at the feet of the defendant? It's a much simpler problem, but we had a lot of witnesses. So, you know, usually this is not contested. But now it is contested, and we have conflicting facts. So what do? I don't think I can just take one side's view of the facts. I have to have live witnesses. Somebody sitting now having their third latte in the Netherlands. We'll have to get on an airplane and come over here and testify. And you bring your witnesses in. How does that work?
Well, in that case, we would request the opportunity for further discovery, Your Honor. We've submitted materials that are publicly available.
I think I have to give you that, and I think I have to give the other side an opportunity to draw into question your discovery, your submission, and then we're going to have an evidentiary hearing. And all the other motions will be on hold. I'm sorry about 12B6. You won't know how that's going to come out. You're not going to get a peek into the future. We're going to find out whether or not Royal Dutch Shell is a party or not to this case.
I would just point out back to the standard. A general manager, and again, this is for purposes of service of process, has been interpreted to include any agent of the corporation of sufficient character and rank to make it reasonably certain that the defendant will be apprised of service. And
I know. In this case, it's clear that they all were apprised.
Correct.
Right. But that's not the test, is it? I mean, I guess I could consider that, but the fact is that if that were true, then no defendant could ever win this motion because they do have actual notice. But the question is whether or not the subsidiary was reasonably likely to be in a circumstance where they would turn the service of summons and complaint over to the parent, right?
Right, and as Your Honor recognized in Cosper, the general manager for purposes of service of process there was a non-exclusive distributor, not even an employee of the company. Here we've alleged in the complaint, which is unrebutted, that Shell Oil Company has been registered to do business in this state since 1949, that it's the named operator of oil and gas wells in California, that Shell Oil Company, along with other subsidiaries, has owned 2 refineries.
Yeah, but these are all subsidiaries. Royal Dutch Shell doesn't do any of that in California.
Royal Dutch Shell does those activities in California, Your Honor, through its subsidiaries. It is the key decision maker in terms of company-wide levels of fossil fuel.
See, that's where you have to maybe take some depositions and find out if that's true or not. Because there really are such things as holding companies. I've seen them, a few in my time. So it could be that there really are a holding company. That's not the way the annual reports ever portray it. I haven't even seen it, but I know what it will say. It'll be a big glossy thing, Royal Dutch Shell. Our operations in California through our subsidiary. Yes, that's exactly what they will say.
But let me put it this way, Your Honor.
But you got to go get your proof. Go ahead.
Let me put it this way, Your Honor. Imagine a scenario in which Shell Oil Company unilaterally announces on its own that it's deciding to exit the fossil fuel business in California.
Yeah?
It would never happen based upon the evidence we've submitted, Your Honor.
Why not?
Why not?
Yeah.
Because it's the parent company that's controlling the decisions about fossil fuel.
Oh, you're saying the subsidiary would never do that on its own.
Correct. Correct. And that's the logical result from their argument that Royal Dutch Shell is a holding company, that this subsidiary could take unilateral action, exit the entire California market without any direction from the parent company. And that just, it defies belief, Your Honor.
Well, I don't know. Maybe that's not the test. But all right, Ms. Kim, you get a reply.
Thank you, Your Honor. I think 3 points at this point. First, you can grant the 12B2 motions to dismiss for lack of personal jurisdiction without deciding the 12B5 motion because they're both jurisdictional. The second point is, Your Honor, I believe my opponent is confusing the distinction between the personal jurisdiction motion and the service of process motion. If, as plaintiffs assert, the mere fact that a foreign parent dictates high-level policies for 1,100 of its subsidiaries is sufficient to make any one of those subsidiaries a general manager under California law, there'd be no reason for the test. The Ninth Circuit rejected pretty much precisely this argument in Miller, where it remanded because it said that the record shows merely that the foreign parent, quote, holds itself and its subsidiaries out as a single integrated global group, and they issue a single financial statement. And the court said that's insufficient. It makes sense. If it were true that the mere fact that a parent company makes board-level decisions like every foreign parent does, and that by definition somehow meant that every subsidiary that exists, just by virtue of the fact that it is a subsidiary and in some form perhaps relays some financial benefit to the holding company, if that were enough, then there'd be no need for the general manager test. The statute would just provide you can serve any subsidiary. That's clearly not what the rule or the law requires. There's no need for jurisdictional discovery here, both for the reason that we can deal with the 12b2 motion, but also because no matter what facts they're able to discover or elicit about RDS's directions to its subsidiaries, the test isn't, for the general manager test, isn't whether or not the foreign corporation controls the actions of the domestic subsidiary. The general manager test, as set forth in COSPER, is whether or not a domestic the entity served manages the, quote, continuous flow of business from the foreign corporation to the state of California. Every case that plaintiffs cite, again, Your Honor, deals with a domestic subsidiary or an entity or an individual in California that sold or distributed a good that was manufactured by the foreign corporation, and the general manager sold the good, distributed the good, dealt with warranty issues on behalf of that foreign corporation. Whether or not Royal Dutch Shell is a holding company and plaintiffs want to oppose or think they have facts that might oppose that, it really is irrelevant here because they cannot, under any circumstances, demonstrate that there is any entity in California that manages the business of Royal Dutch Shell, the continuous flow of business into the state, because Royal Dutch Shell, in and of itself, transacts no such business.
All right, I got a question for you, but it's on a different motion, but and if you're not the one to answer it, that's fine, but since I have you here, Federal Rule of Civil Procedure 4K2.
Yes, Your Honor.
Now, are you arguing that one?
No.
Are you Royal Dutch Shell too?
Yes, Your Honor. David Frederick.
And are you going to argue that one?
I am, Your Honor.
Okay. Well, then the question. All right. Well, let's take it up now. But before I do that, I want to say you did an excellent job. Thank you. I'm glad you had the opportunity to argue this motion.
Very much.
You did an excellent job too.
Thank you, Your Honor.
All right. Okay. Here's my question on the. I've learned the hard way that on these things, when you got an overseas company that says they're not subject to suit in California, then I have to ask this question: what state are you subject to suit in California, in the United States?
No state, Your Honor.
All right. Well, then why isn't 4K2 applicable?
We do argue that you have to analyze this under 4K2, but that the test for 4K2 looks at whether or not the foreign parent has the requisite minimum contacts with the United States as a whole. And we submit that that test is not satisfied for Fifth Amendment due process purposes.
Well, but again, in every other case where somebody makes that argument, I always give them discovery. So now you're opening yourself up to nationwide discovery. You really want to go there, I'm going to let you go there, but they're going to get to travel all the way to the Netherlands, all of your operations in the United States to find out if they can meet the... I'm not just going to take your word for it.
Your Honor,
I can't. That's wrong to do that.
So the way the Ninth Circuit's tests apply here, the plaintiff puts its allegations in the complaint. We have an opportunity through declarations to rebut those with factual information, and we have done that in our motion.
And they get to respond with their own evidence.
And the question, and they have responded.
Yeah.
The point is, every argument they make, every factual averment, is a conclusory allegation that is not specific enough under binding Ninth Circuit precedent.
The point is that the evidence is in your files. How can you expect them to know what's in your files now, there are things that are publicly known, of course, they should be able to find that stuff. But in every other case that I've had, and I shouldn't say every, most of the cases where this comes up, the stuff that comes out of their files kills them. And means that they're going to get subject to jurisdiction, just like you're going to get subject to jurisdiction, probably, whenever they get into your files and find all the bad documents.
Your Honor, they have not alleged any kind of
They have to allege it. I don't understand why you keep saying that. They don't have to allege it in the complaint. It is enough for them to say they have to allege subject matter jurisdiction. Where does it say they got to allege personal jurisdiction?
The Terracom case, which says that conclusory allegations are not sufficient to justify jurisdictional discovery. That's the Ninth Circuit, and what the court held is that where the allegations do not go to specific points that would abrogate the corporate form, you do not have to order jurisdictional discovery, and in fact, you should not order
What's the name of that decision?
Terracom, and the citation is 49 F. 3rd at 562.
Read to me what it says.
Well, it says that the test is whether it's necessary to resolve personal jurisdiction and where the facts alleged are attenuated. And I'll go through all of the facts that they have alleged and explain to you why they are attenuated with respect to the corporate form. You do not need to require jurisdictional discovery.
I don't need to, or I can't?
Your Honor, there's always discretion at certain levels, but the question is whether or not it's necessary to resolve the personal jurisdiction motion.
I want to be fair to both sides. I'm not going to take the lawyer's word for something.
Well,
even if it's under oath, unless they get a chance to probe it.
Your Honor, the test, though, and where there are allegations that have been rebutted with factual declarations, and the Szymanski Declaration that is appended to our motion does rebut that, they have an opportunity, which they tried to do, to say, here are the reasons why we think the corporate form should not be recognized. In every case where Royal Dutch Shell has been sued in the United States, it has contested personal jurisdiction because, as Ms. Kim said, it is a holding company, not an operational company. The test under control is whether or not they can prove that the corporate form is not being recognized by Royal Dutch Shell. The test under the Yamaha case is whether there is substantial control over the subsidiary's activities. Under Doe versus Unical, it's whether there is control over internal affairs or daily operations. The points that he makes and he highlights in the brief do not go to the daily operations. They go to general policy matters.
But how are they going to find that out without taking discovery? Those are very much the kind of things that you would find in the emails inside the company, or how often it is the CEO goes over and dictates what the subsidiary is going to do. That's not going to be in the newspapers. It's going to be something in your files.
It is in the declaration, which says...
And am I supposed to just take their word for it?
If it's not rebutted, yes.
Oh, I disagree with that. That is so unconstitutional that your declaration I have to accept as gospel, and they don't even get to probe it?
Under Twombly, Your Honor, the plaintiff doesn't get discovery without a basis, even if the defendant has the facts. That's the Twombly standard by the Supreme Court.
This is not a Twombly issue.
Sure it is.
No, it's not. You're trying to get out on the basis of a declaration that you don't want me to allow them to take discovery to show that it's misleading in some manner or incomplete.
Your Honor, the allegation has to go to whether or not you disregard the corporate form. And under Doe versus Unical, the Ninth Circuit has held that the standard is whether or not there is control over the daily operations. There's no allegation here by the plaintiffs that in fact Royal Dutch Shell has disregarded the corporate form. And as your questions to Ms. Kim indicated, there are Shell entities that are doing business, subsidiaries that are doing business in California. What they are attempting to do is to impute certain of those activities without having sued those subsidiaries. So what they're attempting to do is to pierce the corporate veil through allegations that are conclusory in nature. But what the Ninth Circuit has held is that general policy setting is not enough. That's the Unical case. Worldwide allegations about branding are not enough. That's the Ranza case. Listing the stock on the U.S. Stock Exchange is not enough. That's the Unical case. And that where there is general control over subsidiaries, that's not enough. That's the Yamaha case. So in each of these areas where the other side has made conclusory allegations, they are of a general nature, and the Ninth Circuit binding precedent has held that is not enough to disregard the corporate form, particularly where you have a declaration from the General Secretary of Royal Dutch Shell who says the Royal Dutch Shell is scrupulous in following the corporate form, and that is why it is not subject to jurisdiction in the United States. The Havlish case, the Southern District of New York, looked at this exact same question on virtually identical facts and held that Royal Dutch Shell was not subject to personal jurisdiction.
All right, what's yours? You get to have a response.
Yes, Your Honor. Counsel is seeking to apply the wrong standard, Your Honor. The plaintiffs here are not proceeding under an alter ego theory of jurisdiction. We're proceeding under an agency theory. Alter ego is where you disregard the corporate form. That's not what the plaintiffs are trying to do here. We are proceeding under the agency theory as stated in Williams, the Ninth Circuit case, where, quote, the parent company must have the right to substantially control its subsidiaries' activities. And that's 851 F. 3rd 1015, Your Honor. And the key activity at issue here that we have submitted evidence on that creates a factual dispute is that Shell, the parent, is the one.
Say Royal Dutch Shell.
I'm sorry.
Because it's so confusing to me. When you just say Shell, I don't know who you're talking about. So use the actual name.
So the evidence the plaintiffs have submitted, Your Honor, which creates a disputed issue of fact, is that Royal Dutch Shell, the parent, is the one that's making the key tortious decision that's at issue in this case, and that is the decision to produce company-wide levels of fossil fuels that are massive. We have submitted the testimony from the Shell subsidiaries from the Greenpeace case, in which they testified that the board of directors at Royal Dutch Shell made the decision to drill for oil in Alaska. We have submitted the 2017 announcement from the Shell, Royal Dutch Shell, CEO, taking responsibility for the emissions from all of Shell's products that it sells, the fossil fuel products. We have submitted the responses to the carbon disclosure report. The response was submitted by Royal Dutch Shell. What did it say? It said that direct responsibility for climate change issues is with the CEO and the board of directors. So that the notion that somehow that this is uncontradicted evidence, on the Szymanski Declaration, Your Honor, we pointed this out in our brief. She was very careful to describe that it was the subsidiaries that were carrying on the operational aspects. This is not a personal injury case about a refinery accident. It's not a case about a pipeline leak. This is a case about Royal Dutch Shell's decision to produce company-wide levels of fossil fuels at massive levels. So we're not talking about operational aspects.
Can I ask you a different question, though? First, a simple question. Do you want discovery or not?
Yes.
Thank you. Next question. A different point that troubles me about your position is that, yes, maybe the headquarters in the Netherlands makes all these important decisions, and yes, maybe that in turn causes the oceans to rise and eventually rise in Oakland. Nevertheless, what are the operations in California that could possibly make any difference in that scenario? What happens in California, big as it is a speck on the ocean. And the rest of the world, the ocean's going to rise regardless of what happens. So don't you, under Supreme Court law, don't you have to have some connection but for operations, at least in the United States, under the 4K test, that at least but for those actual operations, on the ground, that it would make some but-for difference in terms of whether or not Oakland gets flooded or not. I mean, really, one way to read your complaint is things are so bad that Oakland's going to flood no matter what. It's not going to matter what happens in China's out of control. The rest of the world is out of control, and we're going down for the third time. And what has happened in California and the United States is really just a tiny footnote on history. So it's that but-for language from the United States Supreme Court on specific jurisdiction. That's what troubles me about your position. So go ahead, answer that question.
Yes, Your Honor. Yes, we do need to satisfy the but-for test for purposes of personal jurisdiction. The personal jurisdiction test is different than the causation test and the merits, which my colleague will be addressing. That's a substantial factor. But in terms of the but-for test for purposes of personal jurisdiction, I would point, Your Honor, to the DuBose case. That was a pharmaceutical case where the plaintiffs brought a failure to warn claim, among other things, about clinical trials that were conducted all over the country, including in California, that allowed a drug to come to market that injured the plaintiff. And there the court applied the but-for test and said as long as the in-forum conduct is a part of the overall course of conduct.
That Judge Tiger's case?
Yes. And the defendants have all conceded this.
That's a district court case, all right. But all right, so is that the best you have, is a district court case?
That's the one that's most directly on point, Your Honor. And the defendants have conceded that it's not just the forum conduct that has to cause all of the plaintiff's injuries. They all conceded that in the reply brief.
Wait, say that again? They all conceded what?
Initially, Your Honor, the defendants were arguing in their opening briefs that it had to be just their forum conduct in California or the United States that caused all of the plaintiff's injuries. And in the replies, the defendants have said, no, that's actually not our position. And that's consistent with DuBose. That's consistent with the Wilden Pump case. That's consistent with Keaton. Keaton, you had a relatively small amount of sales of the magazine in the forum state. And the Supreme Court held that there was personal jurisdiction for the plaintiff to sue on nationwide harm. Why? Because a part of the overall course of conduct took place in the forum state.
Well, that's not quite right. There was slander and libel in the state of New Hampshire, period. And there was a cause of action for that standing alone, irrespective. So it was okay then to tag along the rest of the nation because that court had definite jurisdiction, or even if it was just one copy of the libel that occurred in New Hampshire. So that's not quite our situation. Our situation here is that even what happened in California is not going to make any difference one way or the other in terms of whether the oceans rise or not. I mean, they're rising, and Oakland's going to get flooded out, and that's going to happen whether or not California operations are considered or not.
On Keaton, Your Honor, the Supreme Court also held that personal jurisdiction would be proper under the single publication rule, in which the plaintiff can, recover all of their damages in one action. And for example, the Wilden Pump case, that was an infringement case. And the evidence was that 1% to 3% of the sales of the product were in California. And in applying the but-for test, the court said we should apply the test to avoid an absurd result. And an absurd result could be, for example, if 90% of the product was sold into California and 10% was sold elsewhere, and the 10% sold elsewhere created its own claim, then the plaintiff would be out of luck because he couldn't satisfy the but-for test. And so that's what the court said. We look at the overall course of conduct, and we ask, but for that course of conduct, would the plaintiff have been injured? And we've alleged that here, Your Honor. This is at the amended complaint, paragraph, 92. Excuse me, Your Honor. Quote, the cumulative greenhouse gases in the atmosphere attributable to each defendant has increased the global temperature and contributed to sea level rise, including in San Francisco. And we make an identical allegation in the Oakland complaint. The defendants have not contested that fact. That is but for causation. Under DuBose, Wilden Pumps, I would also point, Your Honor, to the Adidas v. Cougar Sport case from the District of Oregon. There were 5 sales of the product, to 3 buyers in Oregon, and the court held that the but-for test was satisfied. Again, it's the...
But that argument would mean that they're subject to suit everywhere. Everywhere. Where would they not be subject to suit under your theory?
Well, it's a forum-by-forum analysis, Your Honor.
Yeah?
So, for example, I do not know the extent of their fossil fuel activities in the state of Iowa, for example.
I bet you one of these companies is in every state in the union. Yes.
That very well may be, Your Honor.
All right, so I think your theory would mean they could be subject to suit in every state.
As the Ninth Circuit said in the Mavericks case, which is a website case, Your Honor, where the website was viewable everywhere, but it was also viewable in California. And the defendant made a similar argument in that case, Your Honor, and the court basically said, look, it may be true that if you do substantial business in every state and you meet the other requirements for specific jurisdiction, that you may be subject to jurisdiction in multiple
But we're invoking here specific jurisdiction, right?
Correct.
So it has to be connected with the... All right, we're running out of time, and I got 45 more minutes, so is there anyone else who wants to be heard on personal jurisdiction?
Can I just make one...
Wait, does anyone else want to be heard on personal jurisdiction? All right, come up here and line up if you do, but we're running out of time, and it's going to come out of Mr. Boutros' time. So you wanted to reply.
Just a couple of quick points. The paragraph 92 are conclusory allegations that are rebuttable because they have conceded that the activity on the outer continental shelf, which represents up to 1/3 of the United States' oil production, is not a but-for cause of global climate change. And as your question at the very end indicated, Mr. Crass's theory is that Royal Dutch Shell is subject under 4K2 to personal jurisdiction everywhere in the United States, which would be a revolutionary holding. So our point, Your Honor, is that Royal Dutch Shell should be dismissed for lack of personal jurisdiction under both the corporate separateness test, which under agency does go to parental control of day-to-day operations, as well as the but-for cause, which my colleague from Exxon will address.
Thank you. All right. Next, please.
Good morning, Your Honor.
Briefly, please.
Yes, very briefly. And just ExxonMobil, Jaron Jangrabani from Paul Weiss on behalf of ExxonMobil. The but-for argument that Your Honor just touched upon applies to all of the personal jurisdiction defendants, and it's the only argument that ExxonMobil has made as to personal jurisdiction.
Now, you're the one that did not put in a declaration.
Correct, Your Honor.
You might have been the smart one in this group.
We're hanging our hat on the legal analysis,
So I recognize that you didn't do what these other defendants did. They put in declarations, opening themselves up to discovery.
But I would say that the but-for analysis applies to all of the personal jurisdiction defendants, Your Honor.
Maybe. There are a lot of arguments here, and every time I focus on one, you always run off to another one and say, but. Okay, go ahead. What else?
As far as plaintiffs do not and cannot say that any of the defendants' conduct in California is the but-for cause of their injury. I just heard counsel once again point to his allegation that all of the conduct of the defendants worldwide causes their injury. Leaving aside whether that's true, because plaintiffs cannot assert that the conduct in California caused their injury, that's fatal to personal jurisdiction in California. That would be saying that anywhere...
Well, where could they be sued?
Certainly Exxon can be sued in Texas or in New Jersey, Your Honor. That's where we're at home. There is general jurisdiction over us, assuming that this complaint has any validity at all.
All right,
certainly
so
there is
Exxon at least admits you could be sued somewhere in the United States. All right.
That's right. And separately, Your Honor, I mean, I think this goes back to what Your Honor touched upon, which is the general jurisdiction principles. That we have to leave that to one side. They have to assert specific jurisdiction here as to these defendants, and they have not done so. They have decided that they do not want to and cannot disaggregate the conduct that leads to their harm, and having accepted that, At best, what they're trying to do is sort of apportion it as between defendants. They do not and cannot attribute any of the harm that they're alleging to the defendant's conduct in California, and therefore there's no specific jurisdiction as to these defendants in California. It's not enough to say that we are somehow involved in business activities here. There has to be a direct link.
How do you answer the counsel's point where he says, look, if you look at it in the aggregate, this activity and the worldwide aggregate, it's all spread out thinly across the globe, and part of that is in California, but added together, it is doing great damage to the oceans and in turn to California. That's the argument. And so, if not in California, it's all spread out thin everywhere. And so if you're not subject to suit in California, you wouldn't be subject to suit anywhere. It's the exact opposite of that. So how do you answer that?
Well, I think putting aside that I think there are serious problems on the merits with that theory, Your Honor, and Mr. Boutros is going to address that on behalf of all the defendants, putting that aside, from just a personal jurisdiction perspective, that means there is no personal jurisdiction here. The case law is very clear that there has to be a link to the harm between the conduct and the harm that occurs in the jurisdiction in order to get specific jurisdiction. The cases that he's referred to, they're cases like libel, they're cases where there's an infringement, where the place where the action occurs, so if the infringement happens, if I sell the counterfeit handbag in California, there's an injury in California, there's conduct in California. What he's alleging is that the decision to produce oil, which they acknowledge wasn't made here in California, that decision gives rise to jurisdiction anywhere then that these global companies conduct any piece of their business. The actions that are alleged as to ExxonMobil in California, Exxon branded gas stations, Exxon credit cards, 2 closed refineries. There is no allegation as to how that activity leads to is the but-for cause of any of their harm.
Where could this claim be, forget about general jurisdiction in New Jersey and Texas, that's general, specific jurisdiction. Where could Exxon be sued under a specific jurisdiction theory for this claim?
Well, I think, Your Honor, then that gets to the idea that their claim, they are trying to create a tort that doesn't require but-for cause, and even if that were allowed on the merits, and I would submit it's not, but even were that allowed, the Ninth Circuit is crystal clear that where there is a tort that has broader liability than but-for, that does not create personal jurisdiction over a defendant where there is no but-for conduct. And I would refer you to the AT&T case.
AT&T,
That was a CERCLA case where apportionment liability was at play, but nevertheless, because the absent defendant had not committed any but-for conduct in California, the fact that they might be liable under that regime didn't mean that there was jurisdiction here.
All right. Let me, wait, let's go hear all three, and then I'll give you a brief rebuttal.
Thank you, Your Honor.
Your name and who you represent.
John Hughes for BP PLC.
Thank you.
Your Honor, BP PLC does not make a corporate separateness argument. It makes only a but-for argument, and what BP has demonstrated...
Did you put in a declaration?
We did, Your Honor. What our declaration did, though, was to try to help walk the court through the materials that the plaintiffs have relied on. So, in other words, the plaintiffs, in their complaint, cited to a study by a fellow named Heedy, which attempts to, I think, deal with this causation issue. And what Mr. Heedy has attempted to do is identify the percentages that any particular company or contributor may have contributed to global emissions or should be viewed as being responsible for. And what the materials that we submitted was to walk the court through what he cited and to show that if you limit what Mr. Heedy's talked about to facts that are relevant to the but-for causation issue for personal jurisdiction, the amount that could be attributed to BP would be a fraction of a fraction of a fraction of a percent. And under the Ninth Circuit's but-for analysis, the question the court has to ask is, if BP hadn't produced any energy, hadn't produced any fossil fuels, would the seas have risen? Would the temperatures have risen? Would they have suffered the injury that they've suffered? Would they want to still construct their infrastructure and sea walls? And the answer to that, of course, is yes, because as the court observed a few moments ago, we're talking about a speck in the ocean with respect to any one particular contribution, even if we look at it under 4K2, to BP's production throughout the United States.
But you can say that about every location. So they're all a spec, but they add up to something big. But every venue is going to be a spec. So that's council's point. So how do you deal with that?
Well, I think, Your Honor, it's really because of the nature of this tort. So you're not going to end up with, there is, at least not in this case, there is no location or defendant or company as to what that you could say satisfies but-for causation, who is the one who, without that company's participation, we wouldn't be in the situation we are. And it's because, and it's going to connect to what Mr. Boutros, I think, will talk about shortly, that this is such a diffuse problem and one in which billions of people and companies and entities have contributed to, that we don't have a person who can satisfy or a defendant that can satisfy but for causation. But that's not a reason to ignore the Constitution. And if I could, Your Honor, remind a court of something the Supreme Court said in Bristol-Myers Squibb in the 2017 decision, which is to focus the court's attention for purposes of personal jurisdiction on the interests of the defendant. And the court says the primary concern is the burden on the defendant. And it says it's not about whether it's convenient or the company could afford to send representatives to be in court in San Francisco. It says it encompasses the mere abstract matter of submitting to the coercive power of a state that may have little legitimate interest in the claims in question. And even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has a strong interest in applying its law to the controversy, and even if the forum state is the most convenient location for litigation, the Due Process Clause, acting as an instrument of interstate federalism, may sometimes act to divest the state of its power to render a valid judgment. And in this instance, BP PLC is an entity that is registered in England and Wales. It's headquartered in London, and it is not subject to general jurisdiction. The defendants that could be sued with respect to an issue under general jurisdiction, you could find them in the places where they're at home. But as to specific jurisdiction, the plaintiffs are not going to be able to satisfy but-for causation.
All right. Next.
Your Honor, Tracy Renfro on behalf of ConocoPhillips. I'll be brief and quick. I make 3 quick points. ConocoPhillips, the defendant presently before the court, subject to this motion, is also a holding company, a non-operating parent of various operating entities. Originally, the complaint filed by plaintiffs named ConocoPhillips Company, which was an operating company. When they amended their complaint, they dropped the operating company and added only the holding company parent. Many of the arguments you've heard today by Shell apply equally as to why there is no jurisdiction, either general or specific, as to ConocoPhillips, the holding company parent, which has no operations in California, never has and has none today. So that's my point number 1. There's no specific jurisdiction as to ConocoPhillips, the parent holding company. To your question, where could ConocoPhillips be sued? In Texas, where its principal place of business, or in Delaware, where it's incorporated, but not here in California?
Those are both general jurisdiction, right?
They are.
So where could they be sued on specific jurisdiction?
Respectfully, Your Honor, nowhere under the theory articulated by the plaintiffs. And as you're going to hear from Mr. Boutros, what they are calling a nuisance theory of tort is not a tort. It doesn't fit into that nuisance
Maybe you're right
paradigm.
about that, but I'm not going to decide that issue until we find out who's before the court and not. So I'm not going to just go, see, then if I were to rule for you, you would then say, oh, great. And then you would never get around to ruling on the jurisdictional issue. You've raised this jurisdictional issue, and we're going to wade our way through that before we get to resolving the merits.
And we very much appreciate that, Your Honor, and have asked for that relief from the court. My second point is, as to the theory articulated by plaintiffs, the court is correct that it would lead to the result, it would violate the ruling in Daimler, which tells us not to accept a theory of specific jurisdiction that leads to a pro-jurisdiction outcome every time. And that's what would happen here if the court were to adopt the plaintiff's theory of specific jurisdiction. That is, decisions made by a parent holding company, even if they had a little bit of an effect here and a little bit of an effect there. Under that theory, specific jurisdiction would be found as to every company everywhere in the country, and Daimler specifically counsels against that. That was the problem the Daimler court said we should not violate. My third and final point is this. To the extent that counsel for the plaintiffs attempts to identify a specific action or contact by ConocoPhillips through the Polar Tankers subsidiary, in Plaintiff's Exhibit 1, ECF page 9, that allegation is disproven. In plaintiff's own exhibit, which is the 10K for ConocoPhillips, and there it explains that Polar Tankers, a subsidiary that supplies and delivers oil into California, is not owned or operated by the holding company parent. The holding company parent, ConocoPhillips, has absolutely no operations whatsoever.
Thank you. All right, your rebuttal to all three, please.
Yes, Your Honor. Let's be clear. There's different but-for tests, and the defendants are muddying them up. There's the but-for test under personal jurisdiction. There's the causation standard on the merits in this case, which will be addressed in the next motion, which is substantial factor. And then there's the Outer Continental Shelf Lands Act but-for test. And that but-for test, Your Honor, as we explained in our remand briefing, requires that the defendant's conduct on the OCS cause all of the plaintiff's injury. That's not the but-for test for personal jurisdiction as applied in the Ninth Circuit, which is that the defendant's overall course of conduct, including the part that's in California, has to be a but-for cause of the plaintiff's harm. And the defendant said that we're only relying on infringement cases. That's not right, Your Honor. Dubose was not an infringement case. Dubose was a personal injury case involving clinical trials. So it was not true that there was a separate cause of action based on just the conduct in California. It was the overall course of conduct of the clinical trials across the country, including a small part of them which took place in California, that was the but-for cause of the plaintiff's harm for purposes of personal jurisdiction. We are proceeding here under the agency test. I keep hearing from the defendants corporate disregard the corporate form. That is not the agency test. I would refer to, Your Honor, excuse me, to the Williams case, the Ninth Circuit case, the AT&T case, and the Weaver case. The test under those cases is you are subject to jurisdiction if you directed your subsidiary to take actions in the forum. And for each defendant, we have submitted evidence similar to the evidence that I discussed for Royal Dutch Shell that shows that it is the parent company that makes the key tortious decision in this case and directs its subsidiaries operationally to carry out that conduct in California. And it's been going on in California, Your Honor, for decades. This is not some kind of random or fortuitous availment of the forum by the defendants. This is part of their overall fossil fuel production scheme, and they have purposely decided to do fossil fuel-related activities in California, which is one of the larger fossil fuel markets. Not surprising. As Your Honor recognized, we've put forward facts. We think we're entitled to discovery on this. We've given you publicly available evidence. I also find it ironic, Your Honor, that the defendants are up here saying that we're trying to substitute a finding of liability for personal jurisdiction. That's not what we're trying to do. We're not starting and ending the personal jurisdiction test with a finding of liability. We're not saying, oh, you've committed a nuisance, so you're liable. The AT&T case that they point out from the Ninth Circuit, the plaintiff's argument was, you're liable under CERCLA, and so, gee, you're subject to jurisdiction. That's not the argument we're making. Our argument is that they're subject to jurisdiction because they're the key decision makers on the key tortious issue, and they directed their subsidiaries to take extensive fossil fuel-related conduct in California over decades. Your Honor, I'll end with this. The end result of the defendant's argument, boiled down, is that a company that does business everywhere would be answerable nowhere. That's not the law in the Ninth Circuit. That's not the law under the but-for test. Thank you, Your Honor.
All right, thank you. We will, my court reporter's been going 2 hours, and I'm going to give her a 10-minute rest, and then we'll resume in 10 minutes. Thank you. All right, we have yet another part of this is a motion to dismiss for failure to state a claim. Mr. Boutros, are you going to make that argument?
I am, Your Honor. I am representing Chevron, and I'm going to argue for all defendants. The court has jurisdiction over my client, Chevron, so we don't have to worry about any of those issues and can get right to the merits.
Right, go ahead.
Thank you, and may it please the court. This court has ruled that federal law governs this case. So now the question is whether the court should recognize a new federal common law claim for alleged global climate change injuries against these 5 companies for their oil and gas production activities around the world. And Mr. Crass, in the last round of arguments, I think made very clear, maybe 4 or 5 times, that the key tortious decision that they're targeting is the simple decision to produce oil and gas.
Well, now let's be, where did that get, where do you say that last round, is that conceded? Read that to me.
Yeah, he said in several times there that the key tortious decision to produce is the decision to produce fossil fuels, and then in their opposition brief at page 13, Your Honor, they disclaimed the notion that the promotion claim is part of their substantive liability claim. They said it's not an element of the federal common law nuisance claim, and that it really goes to their causation argument, which I'll come back to. And they said, quote, the primary conduct giving rise to liability remains defendants' production and sale of fossil fuels. So the question of whether there's a federal common law cause of action, I think the answer is no. And the Supreme Court's decision last month in Jesner v. Arab Bank, which this court asked us to address, provides a roadmap for how to make that decision, and it explains why the answer is no. So I'm going to start with Jesner, Your Honor. The court in Jesner made clear that federal courts must exercise great caution when adopting or recognizing or extending federal common law claims because of the limited nature of federal court jurisdiction. And the court announced a test, and I'm going to come back to this test today several times. The test is, quote, if there are sound reasons to think Congress might doubt the efficacy or necessity of a remedy, courts must refrain from creating the remedy in order to respect the role of Congress, close quote. Here, there are many sound reasons to think that Congress would disapprove of the novel and extraordinary claim that the plaintiffs are asking this court to adopt. First, it would invade Congress's territory under the Constitution. This is a significant international national policy issue, and Congress has repeatedly authorized and encouraged oil and gas production activities. So they're clear Congress would not approve of the rule they're articulating, which would be to deem a public nuisance oil and gas production activities. Second, plaintiffs' proposed new claim, which would regulate conduct around the globe, would interfere with foreign policy and foreign affairs decisions of the United States and invade the prerogatives of both Congress and the executive branch in this sensitive area. And Jesner talked about that a lot, and I hope to come back to that. And third, and the U.S. brief talks about that, Your Honor. Third, the extraterritorial nature of this proposed new claim, it goes into other states, and we have Indiana and 14 other states have talked about this. It would violate principles of federalism by interfering with those other states' energy policy decisions and also their cooperative federalism activities under the Clean Air Act. In short, Jesner and the cases it cites, which include Kiobel, Sosa, and the Ziegler case from 2017, and the principles that Jesner articulates require dismissal of this case. And one thing I think that's really important, Your Honor, about Jesner, and when I went back and looked at it, it really pulls together sort of everything everybody's been talking about in the case, the different doctrines, and if you look at it as how do I go about determining whether a federal court should recognize a claim, it really maps it out. And the court talked about the fact that there needs to be great judicial caution when a court is asked to extend a cause of action. And here, the court quoted this or cited it in the removal, or plaintiffs said that that applying federal, this is in their removal papers, applying federal common law to producer-based cases would extend the scope of federal nuisance law well beyond its original justification. So that's what they need to persuade you to do. And Jesner said when judge-made causes of action are asked to be extended in federal court, the approach is caution. But the plaintiffs are asking this court to basically throw caution to the wind and create a brand new, novel, extraordinary tort that no other court has ever created and that federal courts have repeatedly rejected. And as an example, in Jesner, the court pointed to the Bivens context, where the court declined to extend Bivens liability, civil liability against the federal government, because it would have been a marked extension of that common law action. And it cited the Malesko case. So it wasn't just talking, Jesner wasn't just talking about cases that involve foreign activity, which this case does, but when thinking about any federal common law cause of action, the court is to take a cautious approach and think about whether Congress would approve or disapprove of the action. And the court explained, and it was citing the Ziegler decision, Justice Kennedy wrote both of those opinions, that, quote, the legislature is in the better position to consider if the public interest would be served by imposing a new substantive legal liability. So to elaborate a bit, Your Honor, as to why Congress, the main lawmaking branch, would not approve of this cause of action, let me walk through the reasons in a little bit more detail. First, in AEP, as the court knows, in talking about a potential global warming tort, Justice Ginsburg wrote for the court that climate change, global warming issues involve national and international policy questions and a complex balancing of environmental concerns with energy needs and economic disruption, and those things need to, quote, weigh in the balance, and that it's a complex balancing. And that's why it made sense for Congress to have, in that context, delegated the regulation of emissions to the EPA with its expertise and its ability to bring together experts and the like. Here, the Ziegler case that I mentioned, which that's talked about in Jesner, the court said when an issue involves a host of considerations that must be weighed and appraised, it should be committed to those who write the laws rather than those who interpret them. So here we have the plaintiffs asking this court to wade into the clear territory of Congress and the executive branch when Congress delegates the authority by creating this new regime to regulate oil and gas production around the United States and around the world, and to regulate it and to regulate emissions to change the effect on the world's temperature. And again, that is, to say the least, a big ask, and a cautious approach would not support such a claim. The second reason I mentioned was that why Congress wouldn't approve of this tort, which it doesn't go after how the companies are producing oil, Your Honor. It's not an oil spill case or a pollution case. They're just saying, and Mr. Crass was very clear, it's the production itself. It's whether they produce. That's, in his words, the key tortious decision. But Congress has repeatedly expressed and authorized and encouraged oil production. We cited the Energy Policy Act of 2005, the Energy Policy Act of 1992, which encouraged the Secretary of the Interior to increase the recoverability of domestic oil resources. They want to say that's a public nuisance. Congress says, produce more oil, we need to protect our national security and our independence on energy issues. The United States amicus brief walks through Congress's authorization for oil production on federal lands, the Federal Land Policy and Management Act, the National Forest Management Act, and the Outer Continental Shelf Lands Act, among others, encourage and regulate and foster oil production and activities. So Congress, from all indications, plainly does not want the federal courts to create a new tort that says those activities that Congress has explicitly encouraged and authorized is a tort. I think that's clear from all of these statutes. Congress has made clear that oil production is not a public nuisance, it's a public necessity, and it's authorized the activity. The other feature here, another reason why we can, and this really goes to the core of Jesner, why we can assume and I think determine that Congress would not want the federal courts, and it wouldn't just be, Your Honor, it would be federal courts, district courts all over the country engaging in this analysis, is that the implication of foreign policy concerns, because this is a truly global tort. it seeks to deem part of the liability oil production activities in foreign countries. And in many of these countries, Your Honor, large parts of the revenue from the oil production activities go to the foreign governments or their state-owned oil companies. And so there's a clear foreign affairs, foreign commerce dimension here. And the court in Jesner said that the political branches, not the judiciary, have the responsibility and institutional capacity to weigh those foreign policy concerns. The Jesner court also relied on the Kiobel case, another alien tort statute case. And in Kiobel, the court said that the presumption against extraterritorial application of U.S. law applies with even greater force in the context of federal common law claims, where there's not a statute.
What's the name of that decision?
That's Kiobel, Your Honor. It's 569 U.S. 108, and this language that I'm citing is on page 116.
How do you spell that?
It's Kiobel.
Okay.
And there, Chief Justice Roberts, writing for the court, said that it stressed, and again it was under the alien tort statute, quote, stressed the need for judicial caution in considering which claims should be brought under the ATS in light of the foreign policy concerns, and went on to say that just deferring to the political branches on these delicate, complex issues mandates rejecting extending the tort statute claims and extending liability.
So that was an ATS case?
Yes.
All right. How is that different from the that Arab Bank case? What's the difference in point that those two make?
Yeah, so in Arab Bank, the key question was whether a foreign company could be held liable for a tort when all the activities, or just whether a foreign company could be sued. And so that's what the court ruled, that the answer is no, because of all these foreign policy concerns. In Kiobel, the focus was more on the nature of the particular claim and whether to extend the claim to certain types of activities, but they're very closely related. In both of those cases keyed off the Sosa case, which we also cite, which again was another ATS case, and under ATS, the courts are making federal common law because the statute, as the court knows, is simply a jurisdictional grant. So it's really a fertile area.
One sentence long.
Right, one sentence long, 1789. It doesn't tell us that. So the courts have had to figure out how to make law under that statute. And again, in Sosa, the court said, and this was Justice Souter, that there needs to be judicial caution when making or extending judge-made claims. And here, there are intense federal policy concerns. The plaintiffs are asking this court to deem the production of oil and gas around the world, in all these, including in countries where the companies partner with or work with or deal with foreign governments and foreign entities, and to hold that that's unlawful, basically, it's a nuisance, it's the key tortious decision, would have significant ramifications. All of these cases, Kiobel, Jesner, one of the focuses is that if we allow that sort of claim, if this court were to say federal courts can now deem lawful activity in Germany or wherever to be a public nuisance that can be punished or can be sanctioned in some way to the tune of billions of dollars, those countries, Jesner talks about this, Kiobel talks about it, they can retaliate and come up with the same type of claims and create an international war of lawsuits. And that's one of the reasons that the courts have said in the ATS context, the courts can't delve into this business.
Read back, again, you read it already, but read where the plaintiffs concede that the cause of action would turn on production and not on the so-called false science. Read that again, please.
Certainly, I'll read the whole thing. It's page 8. The easiest spot, they say it in a number of places, is page 13 of their opposition brief. They say, quote, while promotion is one way to establish the liability of a manufacturer in public nuisance law under California law, It is not a legally required element of a federal common law public nuisance claim. The relevance of the city's allegations regarding promotion is that, A, defendants influence consumer demand for fossil fuels, which in turn is a component of the overall pattern of the conduct that was a substantial factor in causing harm to the cities, and B, the misleading nature of the defendant's promotion here goes to their knowledge that fossil fuels would cause climate injuries, i.e. it is indicative of a cover-up, which is relevant to intent. And then here's the final sentence, but the primary conduct giving rise to liability remains defendant's production and sale of fossil fuels. Close quote. Totally lawful activity that Congress has endorsed. California, we've cited the statutes, Your Honor. I had a case in California about the policies of California. Literally, the policy of the state is to maximize oil and gas production in a safe way, but in a reasonable way. But it's to maximize. It's to use our resources wisely, but to maximize production. So to say that it's a nuisance, and the California Attorney General has filed a brief here that is seeking nuisance liability when California itself collects hundreds of millions of dollars of royalties. They sued the federal government last year for royalties. Now they're here asking that the oil companies be held liable for producing oil and gas around the world. It really makes no sense. And on the foreign policy issues, Your Honor, the General Motors case that we've cited, where Judge Jenkins back in 2008 rejected very similar claims against the automakers, they're saying, look, these are fraught with international foreign policy issues that the political branches must grapple with.
All right. Can I ask you to hold your argument at this point and let me hear from the other side? And just on the points that Mr. Boutros has made, and particularly address the concession that he read from your brief. Go ahead.
I will. Steve Berman, Your Honor. Before I answer that question directly, I want to remind the court and tell the court that we don't think, the people don't think, that this is a novel case, unprecedented case in the way they frame it. And I would...
Let's turn up the microphone. I think
I would
somehow that microphone is not as loud, and it should be equal. All right.
I would refer the court to the Supreme Court decision in American Electric Power, where the court held that, quote, public nuisance law, like common law, generally adapts to changing scientific and factual circumstances. And, quote, the federal courts are free to apply the traditional common law technique of decision-making when fashioning common law. And then if you take a look, if you have a chance, at the comment to the restatement, section 821, which is the basis for our case, it's a very interesting...
Okay, I got it right here. So what is it again?
821.
821, okay, what?
And there's a comment to 821 that kind of traces through the history of nuisance cases, going all the way back to the 1300s. And the point I want to make with that history, which went from smoke cases to animal disease cases to pollution cases to groundwater contamination to very sophisticated scientific disputes, is that the law of nuisance has been around forever, and it has responded to changes in mankind. And so what we're here today, before you, Your Honor, is we're applying this decades-old, hundreds of years old law to a new situation. So we're not doing something that is as novel as the defendants claim. Now, to answer your question, did we make a concession that somehow makes a difference in this case? And I would say no. Sure, the primary conduct here that gives rise to the nuisance is the production of fossil fuels. But there are plus factors. And those plus factors are part of our nuisance claim because we're claiming that this was an intentional nuisance. And the plus factors here are the phony science, which we've alleged that they put out, and the misleading promotional stuff, which we allege they put out. You take that constellation of conduct, and that's the basis for our nuisance claim.
Well, see, now that sounds different than what I just heard read to me. Under the restatement is phony science. Where does phony science screw into the statement under the restatement?
I would say it fits into section 825B, and that says that an invasion is intentional if the actor knows that the invasion is resulting or certainly substantially certain to result from his conduct. We allege that as part of proving their intent, that we're going to prove that they understood that they were causing global warming and that they took actions to harm us by mudding up the scientific community's understanding and telling the general public through their promotion that all is good. Use more fossil fuels. It's good for the earth. We also think that the relevance of the plus factors go to the unreasonableness, which is defined in Section 829A.
So is intent a necessary element of what you have to prove?
Well, there's different levels of nuisance. There's you could be negligently create a nuisance, or you can intentionally. And we
well, it is just plain, simple production and sale of oil and gas within the existing regulations without more. Is that actionable under your theory?
Under my theory, it would be, but that's not the way we're proceeding.
Well, it almost sounded that way from your brief, from what was read.
If you read that whole sentence, he read the words. It talks about that the plus factors are relevant to intent.
I didn't even hear the word plus factors.
Well, the plus factors are what I'm calling the science issue and the promotion issue. And we say in the very sentence that he read that they go to intent.
All right, so your theory would condemn even innocent sale of oil and gas, but you say at least as against these defendants, you can prove that they knew better and did it anyway.
It's not innocent. It's unreasonable. So the test under the...
But let's talk about unreasonable for a minute. It has to be an unreasonable interference with the public right, correct?
Correct.
All right. So in doing that, do we weigh into the balance and deciding what's unreasonable? Do we weigh into the calculation the benefit that the world has gotten out of fossil fuels?
Don't.
We don't?
We don't.
How could that possibly be?
Because under the restatement, we are not seeking an injunction. And under the restatement, when you're not seeking an injunction, you don't weigh the benefit because we're not trying to stop the defendant's conduct today or in the future. That's restatement section 821B.
Okay, hang on a minute. That's 821B?
Yes.
All right, a public nuisance is an unreasonable interference with the right common to the general public. Circumstances that may sustain a holding that an interference with the public right is unreasonable include the following. Then there's A, B, and C. Whether the conduct involves a...
I'm sorry, Your Honor. It's comment I.
Comment what?
I.
Oh, I?
Yes.
All right, let me find that. Okay, action for damages distinguished from one for injunction. There are numerous differences between an action for tort damages and an action for an injunction or abatement. And which one are you doing?
Well, we're in between, and I'll tell you why.
Okay. And precedents for the two are by no means interchangeable. In determining whether to award damages, the court's task is to decide whether it is unreasonable to engage in the conduct without paying for the harm done. Although a general activity may have great utility, it may still be unreasonable to inflict the harm without compensating for it. So that's your point.
Yes.
You're saying it's okay to continue selling all this fuel and getting the benefits as long as you pay for the damage.
That's correct, Your Honor.
All right, that's your theory. Okay.
That's why there would be no balancing.
All right, so you say there would be no balancing, but would you nevertheless concede this, that the world, we would be in, just think, isn't it just obvious that we've been using fossil fuels for the entire industrial revolution. We won the Second World War with fossil fuels. If we didn't have fossil fuels, we would have lost that war and every other war. And airplanes couldn't fly. Ocean liners couldn't fly. The trains wouldn't run. And we would be back in the Stone Age. And so we have gotten a huge benefit from the use of fossil fuels, right?
Correct. And
okay, so you concede all that.
Of course I could see there's a benefit.
Well, but you're saying it's still, they got to pay because there's this side disadvantage or harm, injury to the world from carbon dioxide.
Yes, and it was a foreseeable harm that their increased production from the 1980s forward, coupled with the knowledge that they had, because they were the best scientists. In our complaint, you could see they were way ahead of the public scientists on understanding that what they were doing was causing harm, right?
But if they hadn't, if we hadn't gotten energy independence, didn't our country, didn't Congress tell the people in Texas and everywhere else, get out there and drill for oil, find a way to get us off of the OPEC, energy independence? Every president I can remember said we're going to achieve energy independence. And you're saying, no, we should not have increased production.
We're focusing in our complaint mainly on the period from the 80s forward, where, according to our view of science, these companies understood that continued ramping up of fossil fuels was going to cause harm to the environment and
Let's assume that's right. Nevertheless, if the nation is saying, please do it, how can we hold them liable for that?
Well, as we point out in our brief, the nation says other things. As the AEP court said, there are other laws that direct federal officials to take steps to reduce fossil fuel use. And California has such laws. So what we have here is conflicting policies, one apparently to promote, the other to reduce. And the important part, I don't know if this is a displacement argument that's being made or a political question argument that's being made, but looking at your decision on the Clean Air Act, not on displacement, you said, to use the words of the AEP court, is there a statute or regulation that actually regulates the nuisance at issue? And there is no such thing here. Congress has not acted.
Well, for domestic, Congress acted. And what I was saying is that for worldwide, the Clean Air Act is not worldwide, but for domestic, Congress has. That's what the ADP case said, AEP case said.
But you said it had acted, and you made the distinction between emitters and our defendants.
I said that's what you were arguing. I didn't say that I bought it yet. I was saying you made that distinction.
And the statute, I think, makes the distinctions. I still say that. And Congress has not set any law or regulation that tells these defendants two things. One, how much fossil fuels you should produce. Even if they encourage fossil fuel production, no one forced them to ramp it up and produce more when they knew something was wrong. And Congress did not authorize the defendants to lie about the science and to put out false promotional ads that their activities were.
All right, if these defendants hadn't sold, the demand was there, then Pemex or somebody you didn't sue, they would have replaced the demand, wouldn't they?
Well, that's right now. That's be speculative. We don't know how the world would have worked. We're alleging that if they acted differently, we would have been harmed less.
Well,
that's one.
I mean, you've lived through the same time period I have, and you understand how very much dependent our nation has been on oil.
I think you're.
Isn't it logical that if these defendants hadn't ramped up, somebody else would have ramped up?
Well, let's talk about what could have happened.
Yeah.
Let's say in 1980, and this is plausibly inferred from our complaint, in the early 1980s, the scientists from BP, Royal Dutch, Exxon held a press conference, kind of like the tobacco executives did when they said nicotine was not addictive. And they held a press conference and said, hey, world, guess what's happening here? Our scientists know that our fossil fuel production is going to overheat the planet. Congress would have held committee hearings. We would have changed our energy policy if back then the people who knew the most said our product's hurting the environment. So I can't just accept your proposition that someone else would have stopped in and taken over the production. And I think the nuisance law that we've cited to you suggests that that's not a defense, because even if your contribution alone wouldn't be a nuisance, the restatement is very clear that if you see there's a nuisance out there and you continue producing and aiding that nuisance, you're on the hook. On the foreign policy question and the Kiobel case, a couple of things. Number one, I can't tell at times what doctrine Mr. Boutros is invoking. Is it a political question, or is it, some kind of untethered foreign policy concern? If it's a political question, I would refer the court to the AEP case, where the court, in the part of the opinion, Second Circuit opinion that still stands, the court discusses at length why this is not a political question. On the, I'll call it the Kiobel-Jesner trilogy, all of that really starts with a concern that began to arise, and I'm well familiar with this because I had one of these cases that went on for 13 years and was actually decided the same day as Kiobel on the same grounds. But you start with Sosa, you go to Kiobel, you go to the Arab Bank case. And what the courts were struggling with in all those cases is how do we interpret the ATS, and why should we interpret the ATS to give people the right to come to the U.S. over claims where all the parties are foreign parties, all the conduct was foreign parties, and there's virtually no connection to the U.S. other than the Alien Tort Statute. And if you read those opinions, that's what they're about. A concern, the concern in Kiobel and the test that Kiobel came out is whether the claim touches and concerns U.S. territory. This claim touches and concerns U.S. territory. It's here in San Francisco where the harm is.
You're also trying to collect from foreign companies like Royal Dutch Shell for their worldwide contribution to carbon dioxide, right?
Yes.
Not just their operations here in the U.S.
Yes.
So if you succeed, that Netherlands company is going to be regulated by U.S. District Court in San Francisco.
And when it puts when it puts emissions in the stream of commerce that it knows is going to hit San Francisco, I don't have any problem with that. And I was thinking, Mr. Boutros says, well, if we have a judgment here in, San Francisco, that may impede our foreign affairs with the Netherlands. Let me give you an analogy. That risk is out there all the time. Let's take the Volkswagen case. In the Volkswagen case, the U.S. went after the executives. We, the class plaintiffs, went after the executives. $20 billion later, and people in jail in the U.S.
But that's for cars sold in the USA.
But a lot of the conduct was from Volkswagen headquarters in Germany.
But the cars were sold in the stream of commerce, and
I understand.
So that's some. But you're trying to. The only stream of commerce is the. You see the point. Listen, let me ask both sides. I have a calendar that was supposed to start 5 minutes ago. And can I ask you to come back at noon, and I don't have too much more time I can give you, but I can give you more time at noon, and maybe we'll go 30 minutes per side. Does that work?
That would be great, Your Honor. Thank you.
Does that work for you, too?
It does, Your Honor.
All right, so that's what we'll do. I'm going to ask you to just hold your thought right there for the moment, and then go have lunch or something, and I'll see you back here at noon.
Thank you, Your Honor.
Thank you.
Your Honor, Eric Grant for the United States.
Yes. Would you like to come back too?
I'd be happy to come back, Your Honor, if you want to hear from me. If you don't want to hear from me, I'll go home.
You came all the way from Maine Justice?
I did.
All right, I'm going to give you 10 minutes to say whatever you want to say because you came a long way, and then let everybody respond. So you come back at noon too if you'd like.
Thank you, Your Honor.
All right. Yes. First, let's hear from the U.S. government. And thank you for coming a long way, and also for your amicus brief.
Thank you, Your Honor. Eric Grant for the Department of Justice. We appreciate the court's invitation to file the brief and appreciate the court's hearing us this afternoon. Looking at the big picture, Your Honor, plaintiffs' claims are not inconceivable, and we should give them credit for applying old principles to a new situation. But the point is that it is a new situation. These claims are novel, unprecedented, and orders of magnitude greater, and by a new class of plaintiffs, that is, not states, that have been part of the federal common law heretofore. What has the Supreme Court told us about whether federal courts should create such claims? As Mr. Boutros has described, the Supreme Court recently said in Jesner that federal courts should exercise judicial caution. The court in AEP put it this way: it is primarily the office of Congress, not the federal courts, to prescribe national policy in areas of special interest. That's at pages 423 and 24 of the AEP opinion. As this court knows, with respect to domestic emissions, AEP and the Ninth Circuit's decision in native village of Kivalina hold that the kind of national policy making sought by plaintiffs here is inappropriate because it's displaced by the Clean Air Act. And of course, Your Honor, in the order denying remand, distinguished AEP and Kivalina on the basis that those cases involved only domestic emissions. And as we've heard earlier today, this case involves emissions worldwide, including in foreign countries. And one of our points, Your Honor, is with respect, that distinction is not tenable for several reasons. The first is that the Clean Air Act itself addresses international pollution, specifically in Section 115, 42 U.S.C. Section 7415, and we discussed that on page 19 of our amicus brief. In addition, Congress has spoken to international pollution issues, and in particular issues raised by this case in the Global Climate Protection Act of 1987, and we discussed that in our brief at page 18. But I would say more fundamentally, judicial lawmaking in this area is displaced not by a particular statute or set of statutes, but by the Constitution's commitment of authority in this arena to the executive branch and to Congress. The first point about that, as we've talked about in Jesner, judicial caution is at its apex in that arena. Claims that implicate foreign affairs and international relations. Judicial lawmaking in that arena impinges on the rightful discretion of the political branches, and perhaps the Sosa case that we've also discussed discusses that most directly. And then judicial lawmaking prevents the nation from speaking with what the Supreme Court said is with one voice. And there are a couple of cases that we've cited, Crosby v. National Foreign Trade Council, Michelin Tire versus Wages, that make that point. So all of these go to the question whether this court, whether any federal district court, should engage in the type of judicial lawmaking, self-conscious creation of new causes of action and new remedies that the plaintiffs seek here. And the answer in our brief and what I'd like to reiterate this afternoon is the court should not do that. I think one complaint that my colleagues on the other side have made is that sometimes the labels in this area, like the political question doctrine, are imprecise. And that is perhaps a fair complaint. But whether one calls it the political question doctrine or separation of powers more generally, really all of these points, including displacement, go to the fundamental issue of whether it should be Congress and the executive branch, the political branches, or federal courts that make law in this area. And we think that for the numerous reasons we've outlined in our brief, and as Mr. Boutros has also explained, the answer is courts should not do that. And I think just a final point, because I know we're trying to get through a lot here, Your Honor. One thing the court observed in AEP is that this issue involves complex trade-offs among environmental protection, energy needs, which have national security implications, and economic growth affecting a nation of more than 300 million people. And one of the court's observations in AEP is that individual federal district courts really lack competence to undertake that task. And one aspect of that is that there will be inevitable conflict among numerous individual district judges. If Your Honor were to recognize a cause of action, this would be the first case, but certainly not the last. As Your Honor himself said, these defendants under plaintiff's theory would be subject to suit everywhere in every state. And there would be district court judges in every state that would be making these kinds of policy judgments, deciding on whom to impose liability, for what kind of activity, and for how much money. Oakland and San Francisco have each alleged damages in the billions. And that's not hyperbole, that's in their complaint at paragraph 140. And finally, resolution of these issues, these trade-offs in a court is contrary to the norms of democratic decision-making. In the last decade or more, we've had important and hard-fought political battles about these issues, and our citizens have deeply differing views, and the way for those views to be reconciled, if at all, is in the process of the democratic decision-making in the political branches. And so for all these reasons, Your Honor, our answer to your question is no. This court, and certainly other courts as well, should not recognize the type of remedies sought by the plaintiffs here.
All right. Thank you very much. That's Mr. Berman, your turn.
Very briefly. Counsel for the United States says that you would be creating a new claim. You would not be creating a new claim. The federal common law of nuisance has been around for decades, and this is just
but what he said was that it's in a new, you'd be extending it to a new subject matter.
Extending it to a new set of facts, which is exactly what the AEP court said courts were well positioned to do.
But there's no court in the history of the universe that has ever extended this to global warming. True?
That's correct.
So he is correct that the United States is correct that this would be a new step.
It would be, as I said in my opening, addressing part of the evolution of responding to mankind's technology. We're at a new stage, so yes. But the principles, I think, are decades old.
And the United States is pointing to a Supreme Court language that judges like me have to be very careful, proceed slowly, take into account these factors that the Arab Bank case pointed out. So I think that's the point.
In the context of the proceed slowly statement from the Arab Bank case, if you look at that case, again, it's in the context of completely foreign conduct. And the court is worried about, should we be extending our jurisdiction where there's no connection to the United States? Here there is a connection to the United States, right? And so we think that the analogy that they're trying to make with Arab Bank is misplaced. Counsel for the United States said that you would have to make complex trade-offs. I think you and I went over this morning, that under the restatement, we don't think you're going to have to make a trade-off because we're not seeking to stop the conduct. We're seeking to have an abatement remedy, which does not require...
Well, but you're asking for billions of dollars for something that hasn't happened yet in Oakland, for example. And it may never happen to the same extent that you're predicting in the complaint. Why don't we just wait and see if it happens? And if the Corps of Engineers doesn't build a dike and the city of Oakland has to pay millions of dollars for a seawall, okay, then, but that hasn't even occurred yet.
We're already...
And it may not occur until you and I are long gone.
Well, we're already experiencing harm in San Francisco and Oakland. We're responding. We're spending money responding to global...
But your complaint is asking for way more. Give me one example of something that is an out-of-pocket cost that San Francisco has paid.
We have people that we've had to employ, outside consultants, to study global warming and to hire them to figure out how high the seawall should be.
Isn't that paid for by the Corps of Engineers?
Today, but
I think the Corps of Engineers is looking at that.
I think they are, and so are the cities. I know they are because I've sat down and talked to the people who are working on global warming at the city.
But that, all right, even if that's true, that doesn't add up to billions of dollars.
And so,
and it may be they're studying something that could turn out to be a problem. You know, it depends on how accurate the models are. You know, when they have these weather models that can't even predict whether it's going to hit the East Coast or the West Coast of Florida 2 days from now, and now we're trying to predict how bad the global warming will be in 75 years. There's no doubt there's going to be some sea rises, that's for sure, but is it going to be in 75 years or 25 years? You know, things could happen in between, and we don't know yet.
That's what the trial is for. Right now we're at a motion to dismiss. We've alleged that we are being injured and will be injured, and we've alleged it plausibly. And now the question that you're raising would be something that you would decide after you listen to the experts, not on a complaint stage I submit to the court. And
that's a fair point. All right, that's a fair point.
The last point about the billions of dollars, I'm not sure what doctrine that's invoking. We're here on a motion to dismiss. The fact that we may get billions of dollars down the road, it doesn't invoke a political question or a foreign policy issue.
Well, no, the point is, can you get what amounts to damages ahead of time before the damages occur?
That's a separate issue we should be briefing, but again, I don't think it's been brought forward on this motion.
I'm sorry, I didn't hear the last sentence.
I don't think that that's right. We haven't briefed that issue at all.
All right, okay, so that's not yet tendered. Okay.
The last point I'm making in response to the government is this, that he raised a series of generalized statements about foreign policy, foreign relations. But the law requires, if you're going to dismiss this case, that he ground his argument in some legal principle. Is it a political question doctrine? He doesn't want to use that term because they can't meet the test, the Baker versus Carter.
I think the one that they want to use is the displacement and proceed slowly test, which is not the same as political question.
Well, the displacement test, they don't meet because Congress has not spoken, as you put it on your remand motion, to the issue before the court. There's no regulatory scheme that provides a remedy for the cities, which is one of the tests under displacement.
Well,
and proceed slowly, again, I go back to the notion from AEP that you are equipped, and the courts have long been equipped to listen to the evidence, because we're at the complaint stage. Listen to the evidence, decide whether or not there's a nuisance after you've heard everything. And the notion that we're going to have conflicting opinions, well, that's why we have a judicial system that has an appellate branch and a Supreme Court. And if there are a bunch of different district court decisions out there, that's exactly the way our system works. That's all I have on the U.S.
Thank you. All right. Mr. Boutros.
Thank you, Your Honor. I'm going to respond to Mr. Berman's arguments earlier and make a few other points. Let me start, Your Honor, with the Jesner doctrine, what doctrine we're applying. I think you articulated what our theory is. Jesner is not, as Mr. Berman suggests, some narrowly cabined case, nor Sosa or Kiobel regarding the Alien Tort Statute. It states broad principles that the court should consider and must consider in deciding whether to enact or create or extend a cause of action. Let me just read another provision. It goes, and it's not just foreign law. Here, this is Jesner, Your Honor. The court says that, quote, Sosa is consistent with this court's general reluctance to extend judicially created private rights of action. The court's recent precedents cast doubt on the authority of the courts to extend or create private causes of action, even in the realm of domestic law, where this court has recently and repeatedly said that a decision to create a private right of action is one better left to legislative judgment in the great majority of cases. So it sets out a framework, and it folds in the analysis of foreign conduct, of the other factors. And the court doesn't need to reach the political question doctrine. The analysis under these cases say that one massive cautionary road sign is this going to be a tort that would regulate foreign conduct or foreign actors? So that's what Jesner and Sosa do. They state the broad contours and roadmap for deciding whether to extend a cause of action. And Mr. Berman says, well, this is all old material, just new facts. They said during removal that this would extend significantly the public nuisance claim beyond where it's ever gone. And on AEP, if AEP is the best case they've got for encouraging this court to adopt a cause of action, AEP said the opposite of what Mr. Berman said. It said that courts, with all their tremendous qualities, don't have the staff or the capabilities or the authority to bring in and make these policy decisions and decide these complex scientific issues. And they do not have the creative power akin to Congress. So it says the opposite of what Mr. Berman said. And part of the reason the court rejected the common law claim there was because Congress had delegated the authority to regulate emissions to the EPA and let the executive branch, which can bring in everybody and make scientific determinations and have a democratic process, and people can come in and challenge those determinations. The question is whether Congress would approve of this cause of action if it were brought to Congress. That's the question under Jesner. And Mr. Berman, in his arguments this morning, said, well, they're really focusing on the conduct from the 1980s forward. Well, Congress, it's not like Congress has been not perceiving these issues. And as I mentioned, in 1992, in 2005, and 2007, Congress passed laws specifically encouraging and regulating and authorizing oil production activities. So it's during that exact period where they say the activities have been occurring, Congress has endorsed the activity rather than say it should be precluded. The other thing that Mr. Berman said this morning that caught my attention is he mentioned that while there are these laws authorizing oil production and gas production, there are other laws that restrict or regulate it in some areas. And he called those conflicting policies. I don't think they're conflicting because they're just creating a comprehensive regulatory regime for oil production. But they are policies, and that's really our point. They're policies for Congress and state legislatures as well, to a certain extent, to establish for this highly beneficial activity that is essential to human existence. Their tort really is challenging the way human civilization has developed to this date. And that, again, is a huge, huge ask of a court. It's not we're just taking the restatement and applying it to new facts. It's revolutionary, and I give them credit for creativity, but it's a revolutionary tort that isn't cautious. It's to say the least, extraordinarily bold.
You say to Mr. Berman disagreed with the thing you read from his brief and said that you had put the wrong spin on it.
I think I put exactly the right. I didn't put any spin on it, Your Honor. I read it. I could have tried to spin it.
But the word primary was there. So he's saying he said they are not. While it would be within their theory that the mere production and sale of oil would be enough, he referred to plus factors.
Yes.
And that you can consider plus factors for purposes of intent. And then he stated, read from some provisions in the restatement about intent. So what's your response to that?
I have several responses. First, the language plus factors does not appear, as far as I can tell, in the restatement, in any nuisance cases. It shows up in some antitrust cases, I know. But it's not part of the law. So right there, they're asking you to invent a new federal common law doctrine of plus factors. And the reason that they're calling them plus factors is no federal court in U.S. history, and no state court, as far as I can tell, has ever held that public statements about an issue of public concern and public debate and public policy, like how to deal with climate change, that somehow can be tagged as a public nuisance. So that is novel. That's not something that any court has ever addressed. The restatement doesn't talk about that at all. Intent is not a requirement. It's not an element. If someone is dumping a toxin onto my property or onto public property, you can bring a public nuisance case that says whether or not they intended it, they've created a nuisance. So what it really is, Your Honor, is meant to create this rhetorical theme, and it's a motion to dismiss, so I won't get into it, but many of the statements they point to, Your Honor, on promotion, they just disagree that oil is a good product. Many of the statements are just, oil is good, and they think oil is bad. And under the First Amendment, parties are allowed to participate in the process and debate these issues. And we saw at the tutorial, the two smoking gun documents, once we looked at them, they took one out, deleted it from the amended complaint, and the other one they disclosed that it was really a document talking about the IPCC. So there's a lot to say about their promotion claim, but they don't claim that that's the predicate for liability. They claim that it's a plus factor meant to, I think, sort of stir up.
I would like to spend some time on this. So, Mr. Berman, if you could, don't go away, Mr.
Okay.
Nicholas, but I am old enough to remember some of that era, and do happen to remember one ad, maybe one of these defendants put it on, it's maybe 20 years ago. It seemed to, I think it was a refinery down in the Texas area, maybe Louisiana, and there was a watershed that was near the refinery. And the general theme to this ad, I'll describe it in more detail in a minute, but the general theme was whoever let's say it was Exxon. Is Exxon here today? Who is Exxon now? One of you represent Exxon, right? Yeah, okay. So we, Exxon, are a good citizen. Here's our refinery, but look at all this wildlife that is flourishing right near our refinery, and someone dressed up like a park ranger. The idea was that we're a good citizen. Exxon is a good citizen, not just a oil company, but a good citizen. Now, that didn't say a word about global warming. This was 20 years ago. It was more responding to the idea that oil spills occur and wildlife gets hurt and that kind of thing. So Mr. Berman, let's take that ad. Maybe you even remember it. I don't remember it, but your complaint seems to be attacking even that kind of promotion that has nothing to do with global warming, but has to do with we, Exxon, are a good citizen. We care for our neighborhoods. We try to take care of wildlife, that kind of thing. So are you saying that is something that could be a plus factor? An ad like that would be a plus factor that would be taken into account on a nuisance case, your nuisance case?
Not an ad like that, but the ads that we have in the complaint are very different. We have an ad at paragraph 103, or we describe an ad where the companies were saying consumption of fossil fuels at higher levels is a responsible thing to do and is respectful to the environment. They were saying that in an ad at a time that we believe they knew beyond a doubt.
All right, who put that ad out? Which defendant did that?
I don't know, you're sitting here, Your Honor.
All right, do you remember the more details than what you just given?
I don't. But I also, other types of statements that we're talking about, is they're spending money on attacking climate science, right?
Okay, let's take that. There's a difference between raising questions about climate science, versus lying. If somebody is lying to the public, I could see, okay, well, that's not good. But raising questions about climate science.
Well, when you're attacking climate scientists, when you're internally here, there's no fair way that I submit to the court that you can say our complaint says they were raising questions. What our complaint says is that they understood before anyone the relationship between their production and global warming. And they decided that they wanted to attack any person who was saying, look at that relationship. So they knew there was a relationship, and they attacked the people who were saying there was. That is a lie. Now, why is that relevant to the nuisance case? Because Mr. Boutros said something that, frankly, was quite shocking to me. He said, there's no case, he said, in U.S. courts that have ever looked at these plus factors. And we've cited, to Your Honor, 5 cases that have looked at the plus factors. Let's take one.
Yeah.
Just one. The MTBE case, district court. We're finding a nuisance. The court looked at the fact that the defendants had publicly disputed reports about the dangers of MTBE, even though they privately acknowledged that the same findings were valid. The court went on to point out that the defendants conspired to mislead the public in an effort to convince them of the desirability of increasing concentrations of MTBE in gasoline. Those allegations are very similar to the allegations we've made here, and they were relied upon by Judge Shenlin in finding that there was a nuisance. In the MTB Second Circuit case, the court noted that Exxon had gone out and told people that MTB gasoline was just like regular gas, even though it knew this would lead to dangerous contamination. In the ABBATIELO versus Monsanto case, it denied Monsanto's motion to dismiss a nuisance claim because Monsanto made the conscious decision to suppress and conceal PCB risks to its customers and the public. And I could go on with more cases. The fact is that courts have looked at this kind of behavior, and it's the exact kind of behavior that we're alleging in our complaint.
All right, hold that thought. What do you say to that?
I say that, Your Honor, if you look at footnote 3 of our reply brief, we talk about MTB and these other cases. And yes, lawyers, I think Mr. Berman's firm may have even handled that case, but they made allegations like this. But what I said was that no federal court or state court has held that debates about a public issue like global warming can form the basis of a public nuisance claim, which is absolutely true. Not even the Conagra case. There was companies talking about their own products and sort of marketing claims. But MTBE, the Second Circuit decision didn't premise its decision on these allegations of misstatements. It ruled that it didn't endorse that theory. It basically ruled that the verdict could be upheld because the defendant manufactured gasoline containing MTBE and supplied it to service stations knowing that it would leak. So it was a traditional nuisance case. There's no case, and again,
but there was a jury in that case?
I think there was a jury trial, and the jury returned a verdict. So maybe they made arguments like this, but the courts haven't endorsed this as a nuisance theory. And that's why, again, right now, the federal common law, which is what this court would be establishing, this is the law of nuisance. One state can sue another state for pollution coming, or an actor from another state, for pollution coming into the state. They can get an injunction to stop it. That is the law of nuisance. They're asking for a whole new claim where a municipality, not the state attorney general disagrees with them. They call themselves the people today. The attorney general in footnote 2 said, wait a second, they can only do things for their municipality. I, Attorney General Becerra, I represent the entire state. So this isn't the state. So they're asking the court to create a new doctrine where a municipality, and municipalities all over the country, could bring suits. No federal court, and the Supreme Court certainly has not adopted that. They're asking the court to take another big leap to say that not just an injunction, they don't even want the remedy, the only recognized remedy in the law. They don't want an injunction because I think Mr. Berman admitted there are a lot of benefits from oil and gas production. So they don't want an injunction. They want what Mr. Berman called sort of a hybrid. He pointed to the damages provision of the restatement, provision H, but he didn't read the next paragraph of that restatement provision, Your Honor. It says, and this goes to the questions you were asking, it says damages are a retroactive remedy for conduct that has already occurred and injuries that have already been suffered. But as this court pointed out, they're asking for this new remedy into the future regarding future things that might or might not occur.
But is that part of your brief? Did you move on that ground about the prospective nature of the abatement fund?
We did, Your Honor. That was one of our arguments, and that this is a remedy that's just not permissible.
Because I thought Mr. Berman said that was not tendered in your motion.
I believe we made that point, Your Honor, and that this is just a remedy unknown to the public law of nuisance. And it's not, and it's this abatement fund, Your Honor, the closest case, I'm getting away from your original question. Oh, thank you. Yeah, so Your Honor, page 13 of our reply brief, we specifically talk about the relief being unavailable.
Well, wait a minute, that's your reply brief, though. Did you make that point in your opening brief?
Page 22. It just came to me, Your Honor. I remembered it was on page 22. So, and Your Honor, to go back to your point, that as I said, nuisance law is a very simple, straightforward tort. And not only are they asking you to extend it, they're asking you to create a whole new world of elements. By the way, the restatement isn't the law of federal nuisance yet. The court would have to decide, does it make sense? And on this promotion claim, if I can just address it because it's completely incoherent, they're now in their complaint, Your Honor, they now say, in their amended complaint, they explicitly declared that they're not seeking to impose liability or to show causation because of lobbying government officials. And this court asked about the Norr-Pennington doctrine. Clearly, it would bar the claim that, you know, we're lobbying the government and we're making statements to change, to affect government action. So they say that, but then you heard Mr. Berman's example today when you asked what would have happened differently. He said the oil companies, I think I've got this right, the oil companies could have, what if they had held a press conference in the 80s and said we think there's global warming occurring? Well, then Congress would have acted differently. And, you know, one, that's lobbying. It goes directly against what their complaint says, number one. Number two, at the tutorial, I showed you the slide of President Johnson declaring that climate change due to man-made activities is causing warming. We've got to do something. In 1988, about the same time period Mr. Berman's talking about, NASA, I believe it was Dr. Hansen, testified before Congress about these issues. So the notion that they could have a claim based on public debate about issues and that the oil companies should have been saying different things, not only is it a major First Amendment problem, it's absolutely incoherent. And if you think about the rest of it, so they're saying it's just the consumers. Well, there's no evidence that consumer demand would have changed. Would people have changed their behavior? No one's changed their behavior now after 5 IPCC reports. And so it's completely speculative. It's incoherent. No court has ever adopted a theory remotely like this, and the court should reject it.
Mr. Berman.
Yes, Your Honor. Mr. Boutros says no court has adopted this theory, but I just gave you those cases. Now, he apparently thinks they're not part of nuisance law because they were state court nuisance decisions, but the law is pretty clear that when deciding federal common law of nuisance, the federal courts look to the state common law of nuisance. So he's given you no reason why you should not look to the MTBE case, the Exxon case.
MTB was in the federal district court, right?
That's right.
Yeah.
And the city of San Jose case, where the court found that Monsanto intentionally knew the harm, it promoted its product anyway, so it looked at promotion. That's a recent case in federal court here. The lead paint case also went into the fact that the companies had encouraged people to use lead paint in their homes, even though they knew it was dangerous. So there is precedent for our complaint. Mr. Boutros says, well, this is just debate. It's a healthy debate, but we've alleged that they issued false and misleading statements. That's his spin. We're at a motion to dismiss a complaint stage.
But his point, I think, is a different point. He's saying yes, assume that the complaint is right and that the big oil companies covered up this terrible global warming, but still, NASA and the people who run the country and set policy were aware of global warming. And the EPA, for example, do you really think that the people at the EPA could have been fooled by that? They had real scientists there at the EPA who studied this stuff, and they're going to be bamboozled by an advertisement on TV?
Well, if you go back to the brief that our brief Mr. Boutros cited from, we put those allegations in there to establish intent. And there's a reason why we want
but it didn't do any harm if the EPA was doing its job.
No, it was intent to harm us because they wanted to promote fossil fuel production through false advertisements. They wanted to promote fossil fuel production by falsely telling the public and consumers that there was no climate change issue. That goes to their intent to harm us. We have pled an intentional nuisance. We've done that for a reason, because there's no balancing test if you prove an intentional nuisance.
Can I address that question, Your Honor?
Oh, wait a second. Finish your point.
So I have finished, Your Honor.
All right, go ahead.
Yeah, I was going to be next on my list. The court, I think, already pointed to this. It's just flatly wrong that if you're seeking damages, you're not trying to stop the conduct, or you're saying it's intentional, there's no balancing. That's just wrong. The restatement doesn't say that. The restatement, the provision, the comment to the restatement that counsel read said it has to be unreasonable. I don't think there's any more fundamental principle in American tort law that when you're talking about unreasonableness, which is a negligence concept, it's a balancing. Do the benefits and the risks, the benefits of the conduct outweigh the harm or the risks of harm? So that's the test. There are provisions in the restatement, we talked about this, I think, at the removal stage, that say some conduct, the harm is so severe, the court can basically decide as a matter of law that it's unreasonable, but that's not, and there are no benefits. And so there's just no support, Your Honor.
I would like to, maybe you all can do a short 5-page brief just on this one point. But here is this is not a final ruling by any means. This is just my own thinking. If the test is a balancing test of what is reasonable or not, I look at the broad sweep of history and see that we needed oil and fossil fuels, coal would be another one, to get from the 1850s or 1859 when they struck oil in Pennsylvania to the present. And yes, that's causing global warming. That's a negative. But against that negative, we need to weigh in the large benefits that have flowed from the use of fossil fuels. There's been huge, huge benefits. So if you were to say, is it unreasonable and under a balancing test, I think I would normally say you have to take into account the benefit that we have reaped as a world, a huge benefit from the use of fossil fuels. On the other hand, if it's a deal like Mr. Berman says that you cannot consider that, yes, you continue to get the benefit because there's no injunction, but you have to pay damages for the harm, then maybe that's an angle I hadn't thought of. So I think a 5-page brief in the next few days on that one point. I'll give you 10 pages. What would you like? I just would like the benefit of some carefully thought out argument.
Absolutely, Your Honor. That sounds great.
How about a week? A week
A
from
week is
today?
perfect.
That works for me.
Okay, good. All right, I need to bring this all to an end. Can I give you, unless you got something you're dying to say?
I think, Your Honor, thank you for all the time you've given us.
All right, how about you, Mr. Berman? Anything more? We'll give you 10 pages.
I think we're good, Your Honor. I thank you for your patience.
All right, now, let's, I would like to ask the plaintiffs, we're going to do discovery. All these defendants who want to get out of this case on jurisdiction grounds or service of process grounds, no, unless we go through discovery, then yes, maybe. So you have brought this on yourself, I'm sorry to say, but no, you're not going to talk me out of this. So you're going to sit for discovery. I need to know, though, how quickly you could do the discovery you need to meet. And I'm going to give them discovery against your evidence, too. So it works both ways. So how much time do you need as the plaintiff to get it done quickly so that we can move the case forward?
Let's say we serve document requests next week. Then we would get responses in 30 days and give us another 30 days to do whatever depositions we need.
All right, that sounds like 60 days plus maybe 67, 9 times 7 is what, 63? 63, okay, all right. Now, on the defense side, are you going to stonewall like usually happens? But I had cut through it and just, if you do stonewall, I just say, too bad, I'm assuming that evidence would have been adverse and you don't even get a chance to rebut it. So that's the way I deal with stonewalling. But on your side, how long do you, I'm not going to give you a ruling on Mr. Boutros' argument, because you're trying to have it both ways. We're going to find out whether you're in the case or not. Then we'll go to Mr. Boutros and see whether he wins or not.
Your Honor, if you could indulge me 2 quick points.
I'm not going to go back over the merits of this, so go ahead.
I wanted to provide a roadmap, which is that the but-for cause is a purely legal question as to which they've not asked for discovery. So if you were to agree with us on the second prong of specific jurisdiction, you can do so as a matter of law, and it applies to all 4 defendants. You do not need to have discovery.
That's a fair point, but then all these other discovery points are hanging out there, and it would go up on appeal, the Court of Appeals would reverse me, then it would come back and you would say, oh, Judge, we still have these other issues.
We'll protect you on appeal, Your Honor.
No, you won't.
In our favor.
I've heard that. I've been on the job too long to learn that works.
My second point on corporate separateness is that we have moved, and there are multiple pages in our motion papers where we have said they have not alleged facts. So even taking apart the declarations, you have to look at their allegations and whether they match up.
You're going back to the merits. I'm not going to, no, we're not going to re-argue that.
Your Honor, as to the limits of discovery, I think that the point is if the allegation about discovery is limited to the production point and the parental control and direction on the day-to-day operations of production, and discovery is limited in that fashion, it can be done in an expeditious way. But if you were to go into the whole realm of the way that parent holding companies engage in their interactions with their subsidiaries, you are potentially opening up a very broad scope of discovery that is not relevant to the question as they have pleaded it in their complaint.
Well, I'm just going to have to rely upon the lawyers to be reasonably narrow and directed in what the discovery is. As a general matter, if you put forward declarations on subject X, Y, and Z, then not only does your declarant have to stand for a deposition on X, Y, and Z, but you also have to produce evidence that would be reasonably usable by the other side to test and probe, maybe even other deponents. So I just have to rely upon the reasonableness of the lawyers to cabin in and get it done. And I think you on the defense side should get a shot at the additional material that has been laid out by the plaintiff side. if you want to. You may not want to, but if you want to, you should be allowed to do that. Now, the one exception may be Exxon. Where is Exxon? Is it Exxon the one that failed to put in, or not failed, but chose not to put in a declaration?
Because you said we were very smart, Your Honor.
Right.
Ted Wells.
Welcome back, Mr. Wells. It's been a long time. Good to see you again.
Thank you, Your Honor.
I'm going to give some thought to whether or not you should win or lose just on the motion that you brought, because you were good enough to not put in a declaration. But I'm not sure of that, because I got to think about that. The other thing is, who was that lawyer who went head to head with Mr. Heed?
I think that might have been me, Your Honor.
Okay, was that your declaration?
Jonathan Hughes.
Was that your declaration or some young associate in your firm?
Well, he might be younger than me, but it was my colleague and partner, Mr. Lombardo.
Yeah, raise your hand if you're back there. Well, he may have to sit for a deposition if the plaintiffs want it, because if you want me to rely upon his expert analysis, then even though he's a lawyer on your team, too bad, you put him out there. If Mr. Berman wants to depose that guy, okay.
I think Mr. Lombardo understands that that's a possibility, but the one point I wanted to clarify, Your Honor, is BP explicitly said in its papers that it was not challenging for purposes of its personal jurisdiction motion corporate separateness. Notwithstanding that, in the opposition papers, there was a lot said by the plaintiffs that there isn't corporate separateness and we should be able to aggregate the activities, which we didn't challenge. So in our reply, we said that's not challenged, it's not at issue, so it's not relevant. Then in their last paragraph, they said we want discovery on corporate separateness, which, again, we say there's no reason because we didn't contest it.
Well, if you are conceding the point, in other words, if you're willing to concede a point that they're trying to establish on not that we're not contesting it, that's different. If you affirmatively concede a point that they want to establish, then that would eliminate the need for discovery on at least that subject. So if that becomes, I hope you all take that into account in deciding what discovery is actually needed on these motions. All right, good.
So, Your Honor, if we do discovery 30-30, assuming we don't get any Hague Convention issues or roadblocks that might be put up, then you envision a supplemental brief of some kind afterwards?
I do, at the end of all of this. Now, I want to say to Royal, where's Royal again? You're Royal. If you stonewall and say Hague Convention, then I'm going to have to say, look, you brought this motion, you put in this declaration, either the declaration gets struck. You can't do that. You can't hide behind that. I don't think you're going to do that. I think you're going to cooperate in discovery. So,
Your Honor, we are entitled as a foreign company to rely on United States law and rules, and all we have sought to do through these motions is to apply the rules as written and as the courts have construed them.
I'm going to apply the rules as normally applied here, which is if you are putting forward some sworn statement under oath, the other side gets to test it, because otherwise it gives you a blank check, and that's just not right. Okay.
With respect to having them go through the Hague Convention, I would just gently remind you that 2 months ago you issued a notice asking plaintiffs whether or not they would address the, quote, snafu in the service of process. They've had 2 months since then to have gone through the requisite motions to properly serve Royal Dutch Shell. Rather than doing that, they submitted a 10-page brief indicating that they thought that Shell Oil Company was a general manager. If there's delay here, Your Honor, it's not on our part.
Yes, but that's a good point, except that you're the one that's relying upon this service of process thing, and they think it's that they've done it right, and in order to figure out if they meet that test, they get discovery to find out if you're the general manager.
Respectfully, Your Honor, one last additional point. Plaintiffs control how they choose to serve. There is a mechanism in the federal rules for them to ask us to waive service under 4D that does not jeopardize our personal jurisdiction defense. They, again, have not chosen to initiate that process. We can't initiate it. They have to submit the form to us under Rule 4D. They've chosen not to.
They've chosen to go away, that they're allowed to do it under the rules, You have chosen to resist that under a way you're entitled to resist, but they're entitled to now challenge your comeback to that. And I just can't throw it out because it was an alternative way to go.
Of course, Your
Now,
Honor.
I want you, no more on this, no more on the merits. I want you to know something, though. It is, you can't imagine how much work you all have put on me. And I got other cases, and I'm going to do it. I'm going to do all of the work. But strategically, you should ask yourself on both sides whether you are pursuing the right course for teeing these issues up for an ultimate decision. That's what, instead of fighting at every trench like they did in World War I, trench A, trench B, trench C, and then finally they get to the last trench and then they settle. That's the model that I see over there. So you ought to ask whether or not that's the smart way to do this case. But I got to do my job. You've made all these motions. I'm just telling you, I'm going to give some discovery. I'm going to postpone putting some rulings out until we get the benefit of discovery. All right, I've done all the damage to your case that I can do today.
Your Honor, I just want to thank you for taking the time today, and to finish on an up note, hope that when you do get to our motion, you will dismiss the complaint. Global warming is a serious issue, serious problem, but it's not one that can be resolved by lawsuits. So we hope you'll rule that way when the time comes. And again, Chevron doesn't have a jurisdictional problem. So
I know, and even if I were to agree with you, and I'm not going to say which way I would, how much I agree or disagree with you, if I were to agree with you, assume that scenario, then all the other defendants would say, no more discovery, no more discovery. We'll just ride on Mr. Boutros' coattails. No, it's not going to work that way. You're going to go through it. You want all these trenches, you're going to get all these trenches. Okay.
Thank you again, Your Honor. Thank you.
Court is adjourned.